The origins of the Freedom of Information Act go back nearly 60 years. The Freedom of Information Act at the federal level, otherwise known as FOIA, was enacted by Congress in 1966 and became federal law in 1967. Congressman John Moss of California lobbied along with newspaper editors for nearly 10 years, beginning in the Eisenhower administration, for a passage of such law to make available more government information. Many in the media and in the American public felt that the government, including the White House and many different agencies, were controlling information and controlling the media through limiting access of government information. President Johnson did sign FOIA into law, but was initially reluctant and under pressure from other government agencies decided to not veto the bill. Michigan passed its own version of the Freedom of Information Act, otherwise known as PA 422 of 1976, to make more government records available to the public. A public record is a writing prepared or owned, used, in possession of, or retained by a public body in the performance of an official function. FOIA at the federal level was revised in the wake of the Watergate scandal to create a greater level of government transparency.
The Freedom of Information Act, which is commonly known as the FOIA, is a law that gives you the right to access information from the federal government. It's often described as a law that keeps citizens in the know about what their government is doing. Under the FOIA, agencies must release any information that is requested unless that information is protected from disclosure by law. The FOIA also requires that agencies automatically disclose certain information, including frequently requested records. As Congress, the President, and the Supreme Court have all recognized, the FOIA is a vital part of our democracy.
The Freedom of Information Act regulates and sets requirements for the dissemination of information from public institutions. Requests for information must be made to the FOIA coordinator in your school district. Oftentimes, this is the Director of Human Resources, and in some districts, this might be your superintendent. The school district has 5 days to complete the request, or they can notify the requester for an extension of up to 10 days. Districts must act in good faith when responding to requests for information. School districts will receive FOIA requests from a variety of sources. The most typical source that school districts receive FOIA requests from is typically from internal bargaining units. This is very common when the different unions are bargaining with the school district. Local news and publication agencies will often request information regarding employee compensation. Also, agencies such as the Mackinac Center will frequently request information for positions on issues and comparative purposes. Occasionally, districts will receive requests for personnel records. In December of 2014, many changes were made to Michigan's Freedom of Information Act. These changes will go into effect on July 1st, 2015. Public bodies must provide information regarding FOIA requests, including how to make them and what they may cost. This information must be available to the public free of charge. If districts have a website, they must also post this information online. Free copies of the Freedom of Information Act guidelines must also be available upon request and must be provided as part of every FOIA response. Requesters can also demand that the documents and information be provided in an electronic form if the public body has this capacity. The legislative changes also placed caps on what government agencies can charge when taking requests for information. No more than 10 cents per sheet can be charged as a copying cost. Additionally, there is now a mandatory punitive damage of $1,000 awarded to the plaintiff, in addition to a civil fine of $1,000 should a judge find that a public body violated FOIA in an arbitrary or capricious manner. Willful or intentional violations of FOIA rejections issued in bad faith can result in civil fines between $2,500 and $7,500. Additionally, there are cumulative penalties for missing deadlines.
Congress established certain categories of information that are not required to be released in response to a FOIA request, when release would be harmful to government or private interests. These categories are called exemptions. There are 9 categories of exempt information, and they cover information such as classified documents, personal privacy information, trade secrets, privileged communications, and law enforcement interests. Now, even if an exemption applies, the Attorney General has encouraged all agencies to use their discretion and release information if there's no foreseeable harm in doing so, and when disclosure is not otherwise prohibited by the law.
The most recent and contemporary case regarding Michigan's FOIA law was the Howell Education Association versus the Howell Board of Education. The Howell School District responded to a FOIA request from the Mackinac Center regarding union correspondence pertaining to contract negotiations. The Howell Education Association argued that the emails were personal and not public record. The Michigan Court of Appeals ruled in favor of the Howell Education Association and felt that the emails were not subject to FOIA. The court explained that personal usage of the district's email system that is used outside of the public employee's professional role are not subject to a FOIA request. Based on the Michigan Court of Appeals ruling, internal union communications are considered personal emails and are not subject to FOIA requests. The court did establish when an employee's personal email could become public or remain private. A district employee's personal email can become public if the email provides evidence of employee wrongdoing and resulted in a disciplinary action for violation of the district's acceptable use policy. The court further delineated that not all information held on district technology falls under the scrutiny of a FOIA request. Information that is not related to the official acts of a public employee are not a violation of the district policy and are not subject to the requirements of FOIA. The Howell Education Association versus the Howell Board of Education ruling provided clarity to what is an acceptable FOIA request pertaining to personal email on public managed communication systems. The Court of Appeals established that an interpretation of Public Act 422, because the legislation did not specifically address the usage of personal communications via email or storage on a district-owned server. Further revisions of Michigan's FOIA law may address the expanding use of technology to communicate and store public record.